Thank you for the honor of being invited to testify before this committee. I'd ask that my full remarks be submitted for the record.
Without objection.
I am the Chancellor of Patrick Henry College, where I teach constitutional law, and recently, after finishing an LLM in public international law with the University of London, I started teaching public international law as well. There is no doubt about the appropriateness of the aspirations of this treaty. My mother has multiple sclerosis, has been in a wheelchair on a growing basis for about 40 years. I've pushed her around buildings here in this city and in France, Switzerland, and Austria, and there is no doubt on a practical level about the United States leadership on the access for persons with disabilities. But the question is whether or not a treaty is being fairly examined as a treaty here today as opposed to an aspirational statement. This is not like the Universal Declaration of Human Rights, which was an aspirational statement by the UN in 1940s. This is a binding treaty. We don't have to worry necessarily about this committee forcing American law to change. We ought to worry about Americans forcing us to comply with the terms of the treaty, because when we ratify a treaty, we undertake a binding legal obligation to live up to its terms. The thing that the United States should lead on in this area is we ought to be the leading nation in the world in compliance with treaties, fully, fairly, completely. And if we don't intend to comply with the treaty in full, we ought not to ratify it in the first place. If all we're going to do is King's X and say, only thing we're going to do to this treaty is follow existing law, we're doing what Professor Henkin, who's one of the leading experts in the world on this subject, has said, and I quote, "Reservations designed to reject any obligation to rise above existing law and practice are of dubious propriety. If states generally entered such reservations, the convention would be futile. In fact, one nation has entered a reservation to this treaty that says exactly that. The Islamic Republic of Iran declares that it does not consider itself bound by any provisions of the convention which may be incompatible with its applicable rules. 8 nations in the world have objected to that reservation: Austria, Belgium, Czech Republic, France, Germany, Latvia, Mexico, and Portugal, precisely because that approach to treaty laws, we're only going to obey what we want to obey, is incompatible with the object and purposes of the treaty. Contrary to what the person from the Department of Justice said, Article 7 will, in fact, require a change of our law if we're going to live up to the treaty. If we don't have any intention of living up to a treaty, let's just put a reservation in and say we don't have any intention of changing any of our laws. We have no such reservation. And until we do, we have to look and see what the treaty says and what do the words mean. Article 7 changes the law, and we would have a duty to amend the IDEA to live up to its standards. And that means today under the IDEA, parents have the final say for their kids, not the government. Under Article 7 of this treaty, the government has the final say for kids. The reason the IDEA works to protect children is because the government, that's often stingy and stubborn and slow in complying with the needs of special needs kids, is because they know they've got parents with real rights coming after them. And if they don't like what the parents don't like what the government's suggesting, the parents have real authority. Article 7 robs them of their real authority. Again, unless we're just simply going to cross our fingers and say, King's X, we really don't mean what the words of this treaty says. Article 7 clearly it's not a non-discrimination provision as claimed by the person from the Department of Justice. That's just simply not what it says. We ought to read the language of Article 7. It requires the best interest of the child standard to be implemented in every decision. What that means is the government, rather than parents, get to decide what's best for children. And if we think that that's good for children with special needs and disabilities in this country, we don't understand what is appropriate for American children. We need parents as the empowered advocates, and this treaty will take away that empowerment. The most fundamental, nothing is going to happen in any other country until those countries' domestic law incorporates the aspirations of this treaty. Treaties do not build wheelchair ramps. They won't help any American traveling. What will help those Americans is when those other nations implement the provisions in their domestic law and practice. Until that happens, this is all a very expensive and very dangerous exercise in celebrating our aspirations. We will not do anything of substance, and we will do dangerous things instead. Thank you, Your Honor.
Thank you, Dr. Farris.